Ordinarily won't object, but I think the only concern of the penalty is that we don't know number one, we don't have a copy and it wasn't transcribed.
No, we front-loaded it.
Transcription of this?
No, not the transcription, the flash drive.
No, we never got served with it.
No, my lord, we front-loaded it. The evidence in the court record will show. But if you want another copy, we will send you. Please. We can send you another copy.
Please, so that we can make progress. I don't have any issues. But it's just
it was the statement, what he,
allegedly,
what he recorded now, which you are disputing.
But we don't have
the meeting now. You already, in your defense, you deny that you have a response.
My point is that it wasn't transcribed, and this was later brought in, but we don't have the flag.
No, my lord, we front-loaded everything.
No, we were never served with it. Maybe it dropped off or something.
No, but we front-loaded it. I'm sure the court copy will show that we did. We are aware about the rules.
We don't have it.
Maybe it drop off in your office.
No, they never served it on us. But if
my lord, our list, I will give you another copy. But we listed this as document listed. The flash drive is number 34 on the list of documents. No. But you have made that complaint long ago, not today. If you say we'll give you another copy, but we have listed it. It was not your complaint all along until this morning. We'll give you the flag.
So, Counsel, I don't know. What are you saying you want to know?
No, my lord, all I said was that although it's listed in their list of documents, we saw it, but the last time when court, they did not tender it. So it was just my assumption that they no longer wanted to rely on the piece of evidence because we've never received a copy of that flash drive. Although he's saying that it was part of the front-loaded documents, but I mean, it was never said to us. It wasn't part of the documents that were sent.
I don't think.
What I said was that it was not part of the documents that were sent on us. And it's the registry that handles that. So I don't know whether it dropped at the registry or something. I don't know. Or whether the registry was aware that they ought to have served that on us as well. I don't know. But we never received a copy.
My lord, the complaint on not receiving it is belated. When you have served documents long ago, if you have any complaint, you have raised it even before we started this trial. Not that when we want to tender, you now say the document drop off, you are not sure. My lord, it could drop off. But my lord, what I did, like we put an envelope, seal it, stay put. My lord.
Okay.
But that was not your complaint until today.
Because, my lord, a person can list documents in their bundle of documents and decide that they don't want to tender all those documents.
No.
So I'm not conducting Leonard Silk's case for him. So I wouldn't know what documents he wants to rely on and which one he choose not to tender in evidence.
Let us, that's so
I'm not even objecting to it. All I said was that they should avail us a copy. That's all.
My lord will avail my friend, but the practice is this: if a lawyer serves you a pleading with documents, if you have, in fact, before you are the defendant, you must respond to everything. You can write a lawyer or call him that, look, though you listed it on your paper, we don't have it, or the copy you gave us is not legible. We do that. It is not that on the day of the trial, the lawyer will now say the document you gave is not legible. I can't even see when you have pleaded, responded to the process.
Okay, please, Leonard, son, can you oblige us and check the document that is listed as number 34? That's
the flash drive.
Okay, so let me read out what the court has. Maybe it will guide us to know. The 36 documents listed by the claimant on the 20th day of August 2021 as documents to be relied upon at trial. Those documents are 36 in numbers, with the exception of the documents listed as number 34, are all formally admitted in evidence and marked exhibits C1 to C35 respectively. Then a certificate of compliance with the provisions of section 84 sub 4 of the Evidence Act 2011, dated 24th August 2021, is also admitted in evidence and marked Exhibit C36. Then, following questions put to him, he said, I made mention to voice recordings contained in a flash drive. I want the court to grant my release sought in my general complaints and statement of facts. So, obviously, mention was made of this, but what I am not sure of is whether it is one of those documents that were, one of the items that were admitted in evidence.
No, they were not admitted. That's number 34.
34.
That's what we are telling
Yes.
now.
So what it means now, dear Leonard Silk, is that you must necessarily make a copy for them,
Yes.
because this is the only one that is here. I don't know if you have your own, because there is none in the
No, my lord, with what we did
Yes.
when we're from loading, we know that this kind of documents can fall off.
Yes.
So we put it in a special envelope
And sealed it.
and seal it and
Yes.
attach it. But if they have mishandled it, well, my lord, I have no control about officers who work.
They must have mishandled
So,
it
but
because
sometimes because the documents are bulky, so it's possible. But my lord, we'll
Yes.
try to get a copy, but I don't know if it could be released to us and then we'll come here and burnt it out. So a copy.
yes. What do you say?
My lord, that would be fine by us.
Yeah, okay. So I'm going to admit it in evidence, and then, of course, your nobody, your integrity is not in doubt.
No, my lord, we will even come to court with a laptop to
Okay.
copy it
All right.
so that we won't take it away. We'll copy it and get it burnt out.
So, is there any objection?
No objection, my lord.
Okay. Well, is there another special way to identify this? Is a flash drive is a flash drive.
Yeah, my lord, maybe they will have to put an envelope and seal it and tag it so that it won't fall off.
Okay.
And they will have flash the ID, NICN, write the number. So that could be only way.
Yes. The last exhibit was C36. So this one will make it C37. Are we in agreement? So a black flash drive is hereby, without any objection, admitted in evidence and marked exhibit C37.
As a copy.
Okay.
Mr. Ibrahim,
Yes, sir.
you know, what do you want the court to do in respect of the claims you have before the court?
I want the court to hold me my grant relief sought as contained in the general form complaint and statement of facts.
That's all.
Okay.
So it's in the hands of my nephew.
Yes.
My lord, may I humbly request for the exhibits that were tendered previously?
Very well. Go on, take. Show. Exhibits.
Yeah, my first one.
Exhibit C30. C37.
My Lord, I'm so sorry.
Yes.
I have a little bit of a mix up. Mr. Ibrahim.
Yes,
Sorry,
please.
is it Ibrahim or Oladipo? Mr. Ibrahim,
Yes,
how
please.
are you this morning?
I'm very well, and you?
Just let me do the questioning, eh?
Okay.
So, do you recall the date on which your contract of employment was terminated?
3rd of April. My contract was terminated on the 9th of March, 2021.
Which year?
2021, please.
Okay. Yes.
Okay. Can you please take a look at the letter dated? I don't know, do you have, this is the issue with no, 25th?
Yes.
Letter dated 25th March, 2020. I need to check.
March 20.
My Lord, I just want to fish out the exhibit number.
Out of all these ones, I guess they're going on. That is.
Yes.
That's even.
Exhibit C3.
Exhibit what?
C3.
Okay.
Mr. Oladipo, do you have that letter? You know the letter I'm talking about.
I know the letter you're talking about. I don't have any letter with me, but I can remember vividly.
It's on the screen. It's on the screen. It's been shown to you on the screen.
Okay. I wasn't looking up, but I know I could remember the letter. I know everything of her.
Okay. Now, that letter. Sorry. Okay.
Yes, you've seen it. Okay.
Yeah, I can see it.
Okay.
I can see it.
Yes, go on. You see, he's looking at it.
Okay. Now, that letter is a letter that was written to you by the defendant whilst you were still in their employment. Am I correct?
Very correct.
Okay. And the letter was basically talking to you about the risk of, the possibility of a redundancy. Am I correct?
Correct.
Now, you recall having a conversation. I'm sorry, my lord.
Go on.
You recall having a conversation with Yetunde Obrima.
Yes, please.
And in the course of that meeting,
Yes.
in the course of that meeting, can you please tell this honorable court what was said to you in the course of that meeting?
Yeah. On that fateful day, I was informed that it was a continuation of meeting from 3rd of March, 11th of March, and 25th of March. The 3rd of March I was informed of the redundancy. And on the 11th of March, the letter was presented to me, which I rejected, claiming that there was a contractual law binding employee.
Mr. Ibrahim.
Yes, please.
That's not my question. I said you had a meeting.
Okay.
With Yetunde Obrima. You recall having that meeting with
yes,
Yetunde
please.
Obrima? Yes. And I asked you that, do you recall what transpired at that meeting?
Okay, what transpired at that meeting, I remember vividly.
Do you recall? Do you recall?
I recall.
Okay. And at that meeting, you were told that there was the possibility of your role becoming redundant. Do you remember that?
I remember that, but let me correct that notion here that it was not only Yetunde Obrima on that meeting call. It was included with HR, employee relation manager, human resources business partner, and a relief manager of my line manager, Ronke Oluwatomilayo, where I rejected that my role wasn't falling off.
Now, let me ask you a question. Are you aware that there was a restructuring internally in the defendants organization? Are you aware?
I was informed through the letter of redundancy that there will be a restructuring.
Okay. And like I said, you recall having a previous conversation, even though you said that it was not only Yetunde Obrima.
Yes,
but
please.
You had a conversation where this issue came up.
Yes, please.
Okay, please just, my lord is right.
Yes, go on. I'm good.
As the court pleases. But do you confirm that you were informed? I mean, and you said earlier, just a few minutes ago, that it was at that meeting you became aware that there was some restructuring.
No, it was not on that meeting. I said it was a continuation of meeting upon meeting where I've been rejecting the redundancy. So they called another meeting where we have conference call of human resources.
Ibrahim, don't get ahead of yourself. Just be patient. I will get to all of it. I'm asking you a question. I said you were made aware at a meeting that there was.
Yeah, I'm aware.
You didn't hear me?
I heard you very well. I am aware. I was made to be aware of the redundancy of restructuring.
Yes.
Do you also recall being asked or being advised by representatives of the defendants to be on the lookout for other job openings via a portal called Job Watch?
Yes, please.
We're encouraged. Okay. My lord, may I proceed?
Yes, go on.
Thank you, my lord. Are you aware of the fact that there were other employees within the quality assurance team whose roles were also at risk? Are you aware of that?
We are just 2 in numbers. I'm aware.
But it wasn't just you. That's the point I'm making.
Yes, please.
It was not just you who was affected.
No, I wasn't the only one.
Good.
Yes.
Now, in your claim and in your witness statements, you, at several paragraphs, you complained of discrimination. You complained that you were discriminated against.
Yes, please.
Now, how were you discriminated against?
On the meeting held with David Doru, after the redundancy has been rejected, there was an internal investigation handled by employee relation sitting in Ghana and Dubai, where my rejection was upheld. And there was a meeting with David Doru where he was telling me that there are concerns anytime my name comes up.
No. I know. I'm fast, but if I become a machine, you will know also.
My lord is writing, so you need to pick your.
Okay. I'm so sorry about that.
Yes. Now you have mentioned Ghana, you've mentioned Dubai. What did it say happened there?
There was when I rejected the letter issued to me on redundancy, it was investigated by employee relations sitting in Ghana and Dubai. And I was told at the end of their investigation that my concern was partially upheld.
Mr. Ibrahim, you're not answering my question. I said, you complained of discrimination.
Yes, please.
You said yes. How were you discriminated against?
David told me during the meeting conversation that there was a concern that there was a concern that most of the line manager and segment heads were not willing to work with me without any reason given and justification in that regard.
So that's the act of discrimination that you complain.
Yes, please.
Sorry, my lord.
Yes, thank you.
My lord, may I proceed?
Just a minute
Let's
to
go,
agree with me. Yes.
Now, are you aware that the defendant has something like a complaints procedure? If someone has a complaint of such an instance that something like discrimination, if someone has a complaint of being discriminated against, are you aware that the defendant has a complaints procedure that an aggrieved employee can explore? Are you aware?
Yes, I am aware. And I did.
Did you follow that procedure?
Yeah, I followed the procedure by reporting same to the employee relation team.
I'll come to you. I'm mindful of the fact that my lord is writing.
No problem.
Follow up question. Sorry, my lord. Sorry, my lord. What's up?
Arise for a minute.
As the court pleases.
They check it whenever we taste him on the material, I take hopes.
I can't hear you.
Are you hearing us?
Yes, please.
Okay. Okay.
I can hear you.
Can you still hear me?
I can hear you.
You said you reported the issue of discrimination, and I wanted to ask you, did you follow the report procedure? Like, did you go to HR first? There's some feedback. Did you report to the human resources first?
I didn't report to human resources. The bank policy has a policy that says you can speak up and you can pick any bank staff and talk to, which I did to employee relation in Ghana and Dubai.
Okay, if I may ask, why did you not speak to the HR? I mean, you don't work in Ghana, you don't work in Dubai. You are working in Lagos.
I don't trust their judgment in Nigerian human resources.
Okay. You don't trust their judgments.
Yes, please.
Now, you wrote an email. My Lord, may I proceed? You wrote an email complaining of your 2019 appraisal.
Yes, please.
Are you aware of the appeal procedure when you're dissatisfied with your HR, your appraisal results?
Which appraisal are you referring to?
2019 appraisal.
2019 appraisal was reviewed where I was contesting for a promotion that the team I reviewed their job, client due diligence team, some of their staff were promoted. And I, Ibrahim Obafemi Oladipo, didn't get promotion. That was where I was contesting that. How did that one flow very well? Where I am the one reviewing their job, I wasn't promoted, I was stagnant, and the people I'm reviewing their job got promotion.
Okay, and this was, sorry, this was in 2020, right? This decision was taken in, this complaint was made in 2020.
2019 financial year, appraisal comes in March in 2020.
Anyway, you were allowed to, part of your appeal was upheld. Am I correct?
Yes, please.
And you remained in the employment of the defendant in that quality assurance role.
I'm not in that quality assurance role. There's a point of correction. I remain in the bank employment because the judgment says it was partially upheld, saying that they should get me another suitable role due to my qualification and work experience. However, that was what prompted the meeting with David.
You're speaking too fast.
Okay. Okay, sorry.
Trust me as well.
Okay, so sorry.
You can see my Lord. My Lord is writing.
Okay,
that's why my Lord is showing on your screen.
I'm sorry, my Lord. I was in the bank employment. Why? That necessitated the meeting I had with David Udoru.
Mr. Ibrahim, you are mixing up issues. I'm talking about your appraisal now. Your appraisal.
My appraisal wasn't upheld. As in my appeal to the appraiser that I supposed to be promoted, it wasn't upheld.
No, but your appeal was upheld in part. Am I correct?
My appeal was upheld on redundancy.
So on that basis, you carried on working.
I'm not working. I was stagnant.
Mr. Ibrahim, you remained in the employment of the bank.
But I wasn't working in that quality assurance. It has been collapsed.
Mr. Ibrahim, thank you for your answer, in fact. So you remained an employee, true or false?
Based on the letter of employment, I remain in the employment role.
Even though your role had been collapsed?
even though the role has been collapsed.
And you in fact had no role.
I don't have any other role.
Good. Now, you recall, my lord, may I proceed? He had no role, no responsibility. You recall receiving an email and letter, an email of 26 March 2020. You Exhibit C4. You Exhibit C4. Have you shown it to him? (2020).
Please go ahead.
Yes, you recall that email?
I recall the email.
From Myrna.
I'm Najaya. I recall the email.
Yes, okay. I think that's it being flashed on the screen for you.
Yeah, I can see it.
I don't know if you're able to read. There's something that says there's no evidence. I'm actually looking for a particular. But you recall being informed by Myrna that there was no evidence of discrimination against you. Do you recall that?
Yeah, I recall that Myrna told me there was no evidence of discrimination, but I later informed her that through my meeting with David Udoru, that has been on the flash. Right. Okay.
Evidence of discrimination. You recall her telling you that?
There was no evidence of discrimination, which I let her know that a meeting held with David Udoru, the head of retail banking in Nigeria and West Africa.
That's, I'm not yet there, and I'll get there.
My Lord, I think the witness tried to explain. I don't think my nephew would say it should not be that part.
No.
He's trying to let him give the story.
Okay, please speak, Mr. Ibrahim.
He's trying to explain.
Mena was telling me that there was no evidence of discrimination, which I let her know that the meeting held on June 26, 2020, with David Udoru, evidence where they were discriminating me, where he told me that most of the line managers and segment heads were not willing to work with me without any reason given or justification in that regard, as against the bank policy.
Okay. Do you also recall being informed that whatever David Udoru said to you that appeared as discrimination, do you recall being informed that he did not speak the mind of the bank?
Yes, he was trying to defend that. He didn't tell me.
Do you, Mr. Ibrahim, my question is this. Do you recall being told by another officer of Standard Chartered Bank that David Idoru was not, whatever he said to you, that you're making reference to at
Yes,
that meeting,
I was
that he was
recalled
not
by
speaking on
men
behalf
told,
of the bank, that he
men
was speaking his own personal opinion? Do you recall that?
I recall that.
Great. Now, from the period that you were informed around early first quarter 2020, where you were informed that your role was at risk of redundancy, till the time that your contract of employment was eventually terminated, were you receiving a salary? Were you being paid?
I wasn't sacked. They have to pay
You're
me.
receiving a salary?
Yes, please.
Every month. Now, and you said earlier today, but I'm going to ask you again. During this period, what tasks were you performing? Were you performing any roles?
I wasn't performing any role based on the fact that the business did not avail me any role on the outcome of the investigation carried on the partially upheld of redundancy.
Okay. Now, you said in your witness statements that unprofessional treatment was meted out to you whilst you worked in one of the defendant's branches. Am I correct?
Very correct.
Do you have anything before this honorable court to show that you reported that incident to the Human Resources Department?
I've submitted it with my lead counsel of where my complaint was investigated in 2017 by the same guy in Ghana, Edward Ansah, and I wasn't availed the outcome, whether negative or positive. But
you reported it to HR?
I reported to Human Resources Employee Relation in Ghana, not Human Resources in Nigeria.
In Ghana?
Yes, please.
Let me ask you at this juncture, was your employer Standard Chartered Bank Ghana?
It is a one bank, please get it right. You can seek to talk
Mr.
to anybody.
Ibrahim,
yes, please.
Mr. Ibrahim, you need to just take a step back. I'm asking you a question. Were you employed by, because I'm quite familiar with the structure of the
I just told you earlier on that
Mr. Ibrahim,
Mr.
Ibrahim, will you hold on and let me ask my question?
Okay.
Thank you. I'm quite familiar with the Standard Chartered Bank Group, and I know that there are different entities. But when you were employed, were you employed by Standard Chartered Bank Ghana or Standard Chartered Bank Nigeria?
I'm very sure that my loss.
Mr. Ibrahim, answer my question. Who was your employer?
Please let me address you.
As the court pleases.
I can't hear that, please.
My lord has asked that you answer the question, and if the court feels that
okay,
you can elaborate, the court will.
Nigerian employed me.
So you were an employee of Standard Chartered Bank Nigeria?
Yes, please.
But you did not report to the HR of Standard Chartered Bank Nigeria?
Because I do not trust their judgment.
Okay. I did not report because I don't trust their judgments, even though they are my employer and they were paying me salary. As the court pleases. As the court pleases. Do you recall being offered a mutual separation agreement?
I requested for mutual separation agreement at the initial.
But you rejected same, am I correct?
I rejected same because my expectation wasn't met.
My lord, it's mutual separation
agreement. Yes, please, ma'am.
But you rejected same, you rejected the document?
I didn't reject the document. I rejected the payment attached to my request.
You rejected what was offered in the mutual separation agreement.
Yes,
Am I
please.
correct? Now, let me ask you this question. Mr. Ibrahim, and I want you to be very truthful.
Okay.
Remember, you are still under oath. The recording you made of David Idoru, which you have tendered in evidence this morning, did you seek his consent before you made that recording?
I did not seek his consent, and I think in Nigeria,
I
didn't seek his consent.
Don't start giving. You're not a lawyer, so
okay.
Just answer the question put to you.
I didn't seek his consent.
Now, did you utilize the defendant's speak up channel to report the alleged victimization by your line managers?
Yes, I did.
Okay. And do you recall being offered the role of a universal banker by the defendant
Yes,
whilst
please.
you were
Yes, please.
not doing anything? You were offered a role of universal banker.
I was offered a role after I
accept
rejected my
the role?
mutual separation agreement.
Did you accept that role?
I didn't accept that role based on the fact that it is lower to my experience and qualifications.
Okay. Now, that's fine. Thank you. Now, part of the claim that you brought before this honorable court was that you sustained or you're nursing a lumbar spine injury. Am I correct?
Very correct.
Did you ever, and I want you to think properly and think carefully before you answer this question. Did you ever at any point report to the defendant that your injury or your condition was as a result of their furniture?
Yes, I did report to them, and I was offered another chair.
You told them that you had a lumbar spine injury and it was caused by the furniture.
Chair. Yes, please.
And did you, I'm going to ask you this question again. Are you sure that you informed the defendant that you had a lumbar spine injury?
Yes, I did. Yes, I.
The contract of employment.
Yes, I did, because I've been getting treatment through the HMO.
Yes, you were receiving treatment. You were giving time off to receive treatment. But
yes.
Did you state that you had lumbar spine injury? You told them.
Yes, please.
Okay. Now, my lord, may I proceed? I asked you earlier, you said you recall being given permission to attend physiotherapy sessions.
Yes, please.
Now, you were asked. Hold on, please. Please. Now, you were asked to undergo an online risk assessment and training on proper use of furniture. Am I correct?
Yes, please.
Did you do it?
It was yes, I did it after I reported of the injury. I've sustained the injury.
Did you do the online risk assessment?
Yes, I did.
Now, you have also relied on some medical reports.
Yes, please.
Provided by your doctors, right?
Yes, please.
Now, and I don't know, those have they been found out? They haven't been found out.
Oh, yeah, not the doctor will do that.
No, but it's in his witness statement. You made reference to it in your witness statement. So just a minute, my lord. You tendered the doctor's report.
Yes.
Yes, you tendered doctor's reports. Please, can I see the exhibits?
Exhibit C 26,
Yes.
27,
Yes.
28,
29.
29.
Just give me a minute, Mr. Oladipo.
No problem.
But you tendered it. My lord, I'm rounding up. My lord, I'm rounding up. Now, in those exhibits, exhibit C 26, 27, 28, is there, and 29, is there anywhere there? You said you have all the information offhand.
No, my lord.
I've not even asked the question,
No, my
sir.
lord, the documents were made by the doctor. I don't think this witness can answer questions on the medical report made by the doctor.
But he tendered them.
No, but the procedure here, we tender the later on. The
No.
doctor is coming. So if you has any question on the report, you should ask the doctor, not him. He cannot be answering. He's not the author of the doctor's report.
Number one, my lord, I haven't asked my question. Number two, he tendered the documents. He tendered them.
Okay.
If it's a document he tendered, he should be prepared to answer. And I haven't even asked my question. I'm not asking him any technical question. Now, in all those reports that you tendered, your doctor's reports, at least I know it's all written in English. Is there anywhere there that your doctors say that the condition is as a result of the defendant's furniture? If you don't remember, you don't remember.
I remember what the question you asked me now. The doctor they don't have any business telling me it was defendant's furniture. Okay. I only went to the hospital on the complaint of my lumbar spine, and there to do a thorough check of me. There's nothing concerning them.
Did not tell you so. You just came up with that.
The doctor did not tell me that what?
Okay. They did not tell you that your lumbar spine injury is as a result of the defendant's furniture.
Doctor confirmed that it was a sitting arrangement in the office. Sitting there for a long time. They confirmed that to me.
Okay. That's fine. Don't worry. I won't go further on that.
Okay.
Let me just ask you another question. Did your doctors carry out a test of the defendant's furniture? Did they see the furniture? Did they come and carry out a test on the defendant's furniture?
It is not on the bank policy for the doctor to come in to do
I'm
that.
just asking you a question. If they did not, say they did not. Did they?
They didn't.
Now, whether the doctors examined the chair. Are you aware, Mr. Oladipo, that the bank has a right to terminate your contract of employment?
I'm not aware.
You are not aware?
Yeah.
Please look at your contract of employment. I'm going to show you your contract of employment. It's Exhibit C1. I think it's from the NIC control room. Yes, please, can you help me show him Exhibit C1? Item 7. Notice period.
Yes, please.
You can see it and you're able to read it out. Item 7.
I won't be able to read it out, but I can see the paper document there.
Can you see it?
I can see it, but it's faintly on the system.
My lord, with kind permission, may I read it out? It's just a paragraph. But you remember that this is your document anyway, and this is your contract of employment. So I'm going to read out number 7, clause 7.
Please go ahead.
Notice period. Your contract of employment will be subject to 1 month notice of termination by either the bank or yourself, unless termination is on the grounds of serious misconduct, where such termination will be with immediate effect. Do you remember that clause in your contract of employment?
Yes, I do.
Okay. So you now remember.
Yeah.
So is your answer still the same, that you don't remember, you don't know whether the bank has the right to terminate your contract of employment?
He just said on the conduct of on the ground of misconduct.
No, that's not what I read out.
That's what you read out now.
What
That's
I read
what you read out.
That's
1 month of notice in either way.
Except there is misconduct. But what he's saying is that either you or the bank has a right to terminate your contract of employment.
Okay, please proceed.
I think this is a matter of law. The documents.
But I'm just asking him a question. If he could read it, he would have read it out.
A right to terminate. That is why this court is established. So I don't think it's a matter of law.
We're not addressing the court. I'm just doing my cross exam.
Yeah.
Let me check. Check it for me.
Your logic can interpret that document. And so I don't know why you want the witness to return the court as to whether.
I just asked him a question. I'm entitled to ask him a question.
He cannot interpret. This witness can interpret the court.
I'm not asking him to interpret. I only asked him a question, just to confirm what is inside. Is his document? He tendered it. And he said earlier today that he knows everything inside the document. Yeah, I'm just asking him to confirm. Now, do you recall being paid salary in lieu of notice, as well as other terminal benefits? Do you remember?
I wasn't paid any salary.
In lieu of notice, when your contract of employment was terminated, were you paid off, so to speak?
No.
You did not receive any 1 month salary in lieu of notice?
No.
I think it's not. I'm sure. Check out the thing. Mr. Emmanuel, Mr. Ibrahim, I'm going to ask you one more time.
Okay.
When your contract of employment was terminated on the 9th day of March, 2021, were you paid any monies at the point of termination?
I said no.
Okay. My lord, he says no. Mr. Ibrahim, I put it to you that you have only brought this suit in order to harass the defendant. My lord, that will be all for this witness.
Mr. Ibrahim.
Yes, sir.
You recall they asked you about the chairs. After your complaints, can you tell us what happened to the kind of chairs you were using before?
The chair presented.
Asking about the kind of chair. I don't know. I don't know if there's any.
They were using something. He said his chair was replaced.
No. I'm sorry. I asked whether his doctor carried out examination and he said no. I didn't actually ask him about the kind of chair he was using or anything like that.
The doctor said it was the sitting arrangement, but that he did not look at the chair. He did not.
I didn't ask about the chair.
Okay. You asked him whether he complained. You asked him that whether he complained about the chair.
No. I did not say that. That was not my question. I said, did he tell the defendant that his lumbar spine injury was as a result of the chair, and he said yes. He said yes. And I did not go further.
Okay, don't worry, the doctor will come. That's all. They have changed the chairs. Because of
I don't want them.
the chair.
I don't want them.
There are a lot of.
Yes, ma. Yes, ma. My Lord, I can't hear you, ma.
I apply that it should be discharged.
Let them remove him from the Zoom call.
It's a claimant. From witness box.
I was telling him that they have finished with it, so he can now step down and relax. We are done with it. Thank you very much.
Thank you, ma.
We can now
My Lord, we would take a date because my next witness is the doctor. Oh, it's in Nigeria. It's in Nigeria. My Lord, the Zoom virtual one was only for him, and the doctor will be in person. We come in June. No. About 13th. We are trying to suggest.
Just want to do this. I don't think they can screen it.
13th of.
Oh, my Lord, I will beg.
That was very actually. Nothing is very wrong. Not the only time that you do.
We've done that judgment from matters 2021, 2022, even some, we are going to, 2023. But all these other ones, 2012, 2015, 2019, they're still here. So we want to remove them. Then you see these ones are fresh things. The other ones are things. So now if we come back for this is still
Or even September.
No. July. Vacation. My Lord, if you can come early July.
So maybe we finish with the claimant,
and
then
so
we can end
only
for the
be there.
defendant.
Yes.
let's
I don't know whether the 11th of. What about 12th? No, he said 12th of July. The administration. Okay, where did the issue behind the issue behind
July, we can take it.
About 13, I don't know. My life, your logic can give us. Careful, clock.
Oh, no.
This question. That's what I get.
This is
Well, I've heard many looking for. I want to find. Yeah, they might be a spouse, but it's fast.
so. I mean, you have one doctor.
Yeah.
One doctor.
Just one. So you have another person.
No, that's
So that's okay. So we'll only just take that only that doctor. I can't come with my weakness bag.
Oh, that's only doctor. That's
I'm
it.
saying I can't come with my weakness bag. You can't stretch it.
You can stretch it. You're gonna how long? If I thought you were going to then I thought, what are you?
Name shaking poetry. What is that? You don't know. Jen. So Jen look. To go see. Oh, kí ni bá àwọn ọkọ̀ yìí ti bá kọ̀ jẹ́rẹ́ ìwakọ̀ ìjà fótó mẹ́sàn-án lẹ́yìn. This Saturday. Yeah, I've never watched it. It's just another story, so it's just only this season. And I watch it. So, I don't remember. Okay, I don't know. Okay, you know, but only the figure that you got a one part of the